Hi everyone, and welcome to my channel. We have Miss Camelia Ruffin here with us today. She is a probate and estate planning attorney practicing in both Georgia and Florida. She is an Atlanta resident, an identical twin, a wife, a mother of three, a double bulldog, and in her free time, she loves hanging out with her friends and family and being outdoors. Now let's get into this. Can you walk me through some of the most common duties or responsibilities of an executor or an administrator? And also share with me some of the ways that an individual, while they're alive and while they're estate planning, how they can prepare this person to fill this role.
Okay, and I'm glad that you used the terms correctly, executor or administrator. So the difference between the two is that the executor is the person that you nominate in your last will and testament to serve as the decision maker for your estate. The administrator is the person, if you don't have a will, who's applying to the court to be appointed because they're either related to you or have an interest in your estate. Now, these people have a legal obligation to properly administer your estate. It's not going to be their property. They're basically running a business by which they're supposed to marshal, meaning gather all the assets of your estate, secure them, protect them, and make sure that no one else is trying to misappropriate or abuse the assets. So assets meaning bank accounts, real estate, vehicles, business interests, whatever it is that you leave on this earth of value. In addition to that, the administrator and or executor is supposed to deal with your creditors. That's one of the more unfortunate parts of probate, is that if you open an estate, the creditors are supposed to receive notice that it is pending so that they can file claims against your estate. So even if you have $100,000 in an account and then you have $80,000 in debt, technically your executor is supposed to settle all of that debt before any of your heirs or beneficiaries receive any distribution from your estate. So with that being in mind, this executor or administrator is supposed to follow the law accordingly. They're not supposed to favor beneficiaries over each other. If there's a will, they're supposed to follow the terms of the will and not just make arbitrary decisions. If there is no will, then that administrator has to follow the statutory law as far as who's supposed to get what and when. And when I say when, if there are minors who inherit from an estate and you don't have a will and they receive more than $15,000 from your estate, it complicates things because in the state of Georgia, that minor cannot receive that property without a conservatorship being set up. On the flip side of that, if you have a will and you have minor children or minor beneficiaries, you can set up provisions to hold that property in trust so that they can still benefit from that property until they reach the age of majority without the necessity of court intervention.
Subscribe to my channel to learn more about probate real estate, financial literacy, and generational wealth planning.